folks, it's Jay Ramey here. J.K. Ramey, attorney at law, up here at the Know Your Rights bunker in Tulsa, Oklahoma. I am an attorney. I'm an attorney licensed in Oklahoma. I'm licensed in Kansas. I'm licensed in the federal court for the Northern District of Oklahoma. I'm licensed in Cherokee Nation, one of the Indian nations here, and I'm licensed in Muskogee Creek Nation, another one of the Indian tribes here. Cherokee Nation and Muskogee Creek Nation, their jurisdiction kind of covers Tulsa, plus a lot of other area of Oklahoma, and I go to those courts a lot. Anyway, we're here with another episode of Know Your Rights. What is this? This is episode 21. And I think we're going to let Officer Friendly give you the title of this episode of Know Your Rights, because this is something that you always hear, or that you will hear, when you're in your car, out somewhere, pulled over, whatever. This is what you hear from the brave police officers like Officer Friendly. So Officer Friendly, why don't you come on over and tell the folks what the title of this episode of Know Your Rights is. Come on, Officer Friendly.
All right, Randy. Thank you very much for that fine introduction. All right, listen up, because we can do this the easy way. Oh, we can do this the hard way. The title of this episode 21 of Know Your Rights, is Out of the Car, Long Hair.
So what we're going to discuss in this episode of Know Your Rights is, as Officer Friendly said, out of the car, long hair. If a police officer tells you that, says, get out of the car, do you have to get out of the car? The answer, under federal law, as determined by the United States Supreme Court, and which is the law in Oklahoma, we're going to talk more about, can states give you more protection or not? We're going to talk more about that here in a minute. But what's federal law is, the law here in Oklahoma is yes, based on the Fourth Amendment. And we're going to talk more about that in a minute. And we're going to talk more about the crime that they charge you with if you don't get out of the car. But in Oklahoma, in general, the answer is yes, you have to get out of the car if they tell you to get out of the car during a traffic stop. Now, none of the case law I've ever seen says you have to get in their car, because usually if they tell you to get out of the car, they're going to take you back to their car. Have I seen any case law in Oklahoma or the 10th Circuit or United States Supreme Court that says you have to get in their car? I've never seen any. I don't know any. So right now we're just going to talk about, do you have to get out of your car? The answer is yes. And the reason is it's based on this case called Pennsylvania versus Mimms that the Supreme Court decided like when I was like 12 years old, when I was a little kid. We're going to look extensively at that case here in a minute. But I remember I had a case, well, I've had several of these cases where the only crime was the person not getting out of the car. And I had one about a year ago. And my client was recording it, and of course, it was Oklahoma Highway Patrol, and they were recording it too. And the first police officer, Oklahoma Highway Patrol, the one who pulled him over, was kind of a young guy, was actually kind of friendly. And he tells him, get out of the car. And my guy says, I know my rights. I'm not getting out of my car. I know my rights. Well, he didn't know his rights. So, if I remember correctly, the police officer goes back to his car and then comes back and then says, and he knew the case. I noticed some of these cops, they usually know the case. They say, well, under Pennsylvania Mimms versus Mimms, you have to get out of the car, sir. I'm not getting out of the car. So he calls, I think that it was an off-duty cop that came as backup, but it was an older guy. And the older guy was mean and nasty. Get out of the car! I'm not getting out of the car. And so they drug him out. They opened the door, drug him out, beat him down, arrested him. He's charged with, we're going to talk more about this, what you're charged with, obstruction of a police officer. So, without further ado, let's go ahead and just look at Pennsylvania versus Mimms, and we'll kind of read along. And I've highlighted some of the language in it. Well, let's just look right at it. So, before we look at Pennsylvania versus Mimms, let's just briefly look at this state that I just happened to run across as I was looking for Pennsylvania versus Mimms. This is a state case out of the state of Massachusetts, the Commonwealth of Massachusetts versus Rivera, 2006 case. And this is an example of a state using its Constitution, its Bill of Rights, to give greater protection than the federal court has, specifically the Supreme Court, United States Supreme Court. A state can always give greater protection using its own Constitution. They cannot give greater protection using the United States Constitution if the United States Supreme Court has made a ruling on that. A state court cannot overrule the United States Supreme Court, but they can base their decision on their own state court. So I think I've said that enough. So in this case, again, it's out of Massachusetts. It says, however, Article 14 of the Massachusetts Declaration of Rights, which I assume is their version of the Bill of Rights, does not permit the police to force the driver or passengers out of a motor vehicle during a routine stop unless there is a reasonable suspicion based upon specific facts. And I guess that's been the law since at least 1999 because they have a site here, Commonwealth versus, I don't even know how to pronounce that, Gonsalves. I don't know. Anyway, so that's the law in Massachusetts. The police have to have reasonable suspicion based on specific facts. But Pennsylvania versus Mimms says that the police can just order you out of a car for no reason. Any reason or no reason at all. So let's look at Pennsylvania versus Mimms. 1977 case. Mimms got pulled over on some traffic stop, and the police just for no reason ordered him out of the car just because they wanted to. And because they ordered him out of the well, let's just look at give us the facts here. One of the officers approached and asked respondent to step out of the car and produce his owner's card and operator's license. Respondent alighted, whereupon the officer noticed a large bulge under respondent's sports jacket. So he pats him down, finds a gun. Had the police officer not ordered him out of the car, he never would have seen the bulge, is the assumption. And so he never would have been patted down. They never would have found the gun unless he ordered him out of the car. So the Pennsylvania court says, but the court nonetheless thought the search constitutionally infirm because the officer's order to respondent to get out of the car was an impermissible seizure. Again, the Fourth Amendment covers searches and seizures. Since this unconstitutional intrusion led directly to observance of the bulge and to the subsequent pat-down, the revolver was the fruit of an unconstitutional search and, in the view of the Supreme Court of Pennsylvania, should have been suppressed. And of course, this United States Supreme Court, we do not agree with this conclusion. And here's the question. Here's what we come down to. We need presently deal only with the narrow question of whether the order to get out of the car issued after the driver was lawfully detained was reasonable and thus permissible under the Fourth Amendment. Goes on to tell us it was apparently his practice, meaning the police officer that ordered Mimms out of the car. It was apparently his practice to order all drivers out of their vehicles as a matter of course whenever they had been stopped for a traffic violation. The state argues that this practice was adopted as a precautionary measure to afford a degree of protection to the officer and that it may be justified on that ground. So here we go, the old officer safety exception to our rights. We think it is too plain for argument that the state's proffered justification, the safety of the officer, is both legitimate and weighty. So there we go. It's right there in the Bill of Rights. You know, they don't tell us here in this decision, but I know it's right there in the Bill of Rights. The United States Constitution, the Bill of Rights, it's in Amendment 10.1, which says none of these rights apply if officer safety is an issue. Nothing applies when officer safety is an issue. Right there in 10.1 of the Bill of Rights. Look it up on your own. So, there we go. Officer safety. Here we go. About some stupid study. According to one study, this is how we determine our rights. Not by reading the Constitution, but by some study regarding officer safety. Because, again, in 10.1 of the Bill of Rights, it says none of this applies if the court says officer safety is at issue. According to one study, approximately 30% of police shootings occurred when a police officer approached a suspect seated in an automobile. Okay, whatever. So, here we go. It's a very short opinion. We're almost done. We think this additional intrusion, ordering you out of the car, can only be described as de minimis. There we go, de minimis. That's how our rights are looked at by the United States Supreme Court. If the violation is de minimis, and officer safety applies, then the police can do it. What is at most a mere convenience? Here we go with officer safety again. What is at most a mere inconvenience cannot prevail when balanced against legitimate concerns for the officer's safety. So, if the court wanted to, they could say we have absolutely no rights, because, and we're going to look a little bit here in the dissent too, because every decision they make that favors our rights could jeopardize officer safety. Everything. So that's it. That's the decision. The police can order you out of the car for any reason, no reason. They don't need any justification. They don't need any reasonable suspicion, probable cause. They can do it just because they want to show their power and authority over you. All right, let's go down and look at the dissent. Justice Marshall, he first wrote his own dissent, but then he joined with 3 others. He said, in the incident case, the officer did not have even the slightest hint prior to ordering respondent out of the car that respondent might have a gun. Again, this is based on no reason, no reasonable suspicion, no probable cause, nothing. The police can order you out of the car just because they want to, just because they want to show that they have power and authority. So Justice Marshall wrote just a short, separate opinion, but dissenting opinion, but he joined with Stevens, who wrote the major dissenting opinion, which is actually longer, I believe, than the majority opinion. Justice Brennan and Marshall, back in the day, they were always on our side, the people's side. So let's see what Stevens writes here. No doubt it is a legitimate concern about the safety of police officers throughout the nation that prompts the court to give this case such expeditious treatment. I share that concern and am acutely aware that almost every, and this is what I was just saying, that almost every decision of this court holding that an individual's Fourth Amendment rights have been invaded makes law enforcement somewhat more difficult and hazardous. That, however, is not a sufficient reason for this court to reach out and decide every new Fourth Amendment issue as promptly as possible. Again, we're going on with the dissent. The court cannot seriously believe that the risk to the arresting officer is so universal that his safety is always a reasonable justification for ordering a driver out of his car. The commuter on his way home to dinner, the parent driving children to school, the tourist circling the Capitol, or the family on a Sunday afternoon outing hardly pose the same threat as a driver curbed after a high-speed chase through a high crime area late at night. Nor is it universally true that the driver's interest in remaining in the car is negligible. A woman stopped at night. I mean, this is just great stuff here. He's exactly right. A woman stopped at night may fear for her own safety. A person in poor health may object to standing in the cold or rain. Another who left home in haste to drive children or spouse to school or to the train may not be fully dressed. An elderly driver who presents no possible threat of violence may regard the police command as nothing more than an arrogant and unnecessary display of authority. There you go. I agree 100% with that. They're ordering you out of the car when on a simple traffic stop, when they're going to give you a warning or give you a citation to send you on your way. Ordering out of the car just prolongs the traffic stop and just shows that they got the power to make you get out of the car. Here we go. Some citizens will be subjected to this minor indignity, while others, perhaps those with more expensive cars or different bumper stickers or different colored skin, may escape it entirely. So that's right on. Black people, Hispanic people are more often going to be ordered out of the car than some white person, in an expensive car and a nice suit. It's going to be more likely. I'm just repeating myself. Black people, Hispanic people, people like that. Okay, so there we go. That's the decision. The dissent got it right. Well, isn't it more dangerous? Isn't it more dangerous to have the person that may attack you get out of the car and be standing there in front of you? Isn't that more dangerous when they're sitting down and you're standing above them, and you can kind of stand kind of behind, make them have to jack their neck to look at you? That's more logical. If you really want to base this on officer safety, that is more logical. It's more safe to have the person remain in the car, in my opinion. Okay, now let's look at the law in the state of Oklahoma. So, here in Oklahoma, if you refuse to get out of the car during a traffic stop, after they drag you out, they're going to drag you out, they're going to beat you down, they're going to beat you up, they're going to put your face in the concrete or asphalt where they're, punching you and kneeing you and, beating you as much as they can because, they think it's so fun to beat people up just because they wouldn't get out of the car. After all said and done, they got you handcuffed, they're going to charge you with obstruction of an officer. And this is all very general. Here's what it says. Any person who willfully delays or obstructs any public officer in the discharge or attempt to discharge any duty of his or her office is guilty of a misdemeanor. All right, and it goes on to talk about how recording police officers is not obstruction. Now, here's the instruction the jury would be given, which is this part right here. There's some comments and some notes down there. But it tells you no person may be convicted of obstructing an officer in the performance of his or her official duties unless the state has proved beyond a reasonable doubt each element of the crime. These elements are, number one, first, willfully. Second, delayed or obstructed. Third, a specific public officer. You'd put in there, OHP, sheriff's deputy, whatever the officer was. Fourth, known by the defendant to be a whatever, Oklahoma Highway Patrol, sheriff's deputy, whatever. Fifth, in the discharge of any duty of his or her office. Now, this is the Oklahoma Uniform Jury Instruction. It's the uniform instruction. You can add stuff to this. And what I think, if you took one of these cases to trial, what the district attorney would want added to this is, maybe a sixth or maybe somewhere in there, he would want it said, he would add, and then the judge determines whether the jury gets the instruction or not. He would want it added that it is, in and of itself, obstructing an officer to refuse to get out of a car when ordered by a police officer. Like I said, that's not in here, but he would be, based on Mimms, based on the Mimms case, he would probably ask that, that be added in here somewhere. All right, let's go back to my face again, and we'll talk a little bit more about this. So, if I was going to take one of these cases to trial where someone refused to get out of their car and they got arrested and charged with obstructing the police officer, now, like I was saying, the DA would I know that he'd ask to put in, and again, I've never done this. I've never taken one to trial, never talked to another attorney who's taken one to trial, never seen any case law on it here in Oklahoma. A smart DA would want to change around the language of that obstructing jury instruction that the jury reads to say that it is per se obstructing a police officer for a defendant not to get out of his car during a traffic stop. Now, if you went to trial and the DA asked for that jury instruction, and I know the way judges are, they'd go right along with it, and they'd put that on there. Well, you'd be screwed. You'd be totally screwed. But we got to remember, the Mimms decision is a Fourth Amendment decision. It's about the Fourth Amendment of the Constitution of the United States. Is it a illegal seizure of you to order you out of the car during a traffic stop? Mimms is not looking at Oklahoma law and interpreting Oklahoma law and the obstruction of a police officer. That's not what Mimms is. So my argument would be, if I took a case like that to trial and we were to give the jury instruction to the jury, and as we said, the second element there is delayed or obstructed, the defendant delayed or obstructed. My argument would be, him sitting in the car, refusing to get out of the car, does not delay or obstruct. The police officer ordering him out of the car is going to delay the traffic stop, make it go longer. So that would be my argument. I'd say, look, jury, my guy would just sit in the car waiting for to get his speeding ticket or his warning and go on his way. He was not delaying or obstructing by refusing to get out of the car. It did not obstruct writing that traffic ticket. It did not delay, because the police officer just should have gone and wrote the ticket or the warning and sent him on his way. And then, of course, if you lost at trial, then and if the judge would add what the DA would ask for, which would be, it's a per se obstruction of a police officer not to get out of the car based on Pennsylvania versus Mimms, although the jury wouldn't be told based on Pennsylvania versus Mimms. The DA would just say that to the judge. Anyway, depending on what the jury instruction was, you could appeal all that to the Oklahoma Court of Criminal Appeals, but the way they are, they're always on the side of the state, and they would probably come down against you. It would be interesting to take one of those to trial and see what happens. But again, the trial judge is going to rule against you because they're always on the state side. 98% of them are always on the state side. And if you appeal it, it's the Court of Criminal Appeals, which has 5 judges. They're always on the state side. So of course, the client could get a year in jail, so he's sitting there in a year in jail. It's 0 to 1 year. If the jury convicts you of that, they can give you from 0 days in jail to 1 year, and then a fine of, I'm not sure, probably up to $500. So anyway, it's important to remember that Mimms is interpreting the United States Constitution, particularly the Fourth Amendment, and not construction or definition of what is obstructing a police officer under Oklahoma law. Anyway, that's it. So remember, unless you want to pay me a whole bunch of money to go to trial and maybe lose and then have to do an appeal, get out of the car when the police officer tells you to get out of the car in Oklahoma. Now, there's other states, and we're going to talk about here in a minute, Pennsylvania. I just happened to find a case as I was looking for the Mimms case. Pennsylvania, the police have to do a little more to worry out of the car. They can't just do it for any reason or no reason at all. Some of you may be in a state that has a law or case law similar to Massachusetts. I don't know. I don't have time to look up all 50 states. If you're in another state, find an attorney and ask him. If you're in Oklahoma, based on Oklahoma law and 10th Circuit law and the United States Supreme Court under Mimms, you have to get out of the car. But based on the Fourth Amendment, again, it's not, Pennsylvania versus Mimms does not tell you what obstructing a police officer means in the state of Oklahoma. Anyway, I'm repeating myself. Let's get out of here. We'll talk to you in the next episode of Know Your Rights. And if you have a police encounter, do not waive your sacred constitutional rights when having a police encounter. Always assert your rights when you have a police encounter. There's no reason not to. All right, we'll see you guys in the next episode.